Hi there, it's Tara Lucke here. In this video, I'm going to talk about why estate planning is so much more than just a will. There is a really common misconception out there, particularly with lay people, that if they have a will, then they have a complete estate planned. And in fact, for a lot of people, it couldn't be much further from the truth. So stay tuned. I want to walk you through all of the different wealth structures relating to joint property, super, trusts and companies, and explain how that wealth has to be transferred and how it interacts with the will.
So this video is all about why estate planning is so much more than a will. So to make my point, I want to talk you through our estate planning timeline. So there's really three main events that we have to deal with. So the first is losing capacity, and let's face it, to start with, your will doesn't even come into effect at this juncture. That's where our guardian and power of attorney documents come into play. Then we have the next event, which is death, where the will usually comes into effect. But you can't just stop with the will. In terms of a comprehensive estate plan, there's actually a lot of other documents that a person may need. And when we're going through the documents that they may need, I don't want to generalize. Some people will just need a will. Some people won't have any assets really governed by a will. So my recommendation is don't just default to letting your clients assume that estate planning is just a will. There is in all likelihood going to be wealth that does not come under the will at particular points in time, and we need to make sure as responsible advisors that we have all of the documentation that is needed to ensure a smooth transition of a person's complete wealth. So what I want to talk to you about is powers of attorney, where the will isn't relevant at all, but this is actually still one of the most important events that we need to deal with, and then which assets may not be dealt with by a will. So the power of attorney, this applies while a person is still alive, okay, before death. And I can tell you there is something worse than dying, and that is having people who you do not like or trust taking control of your financial affairs and your medical or lifestyle treatment decisions if you cannot make those decisions for yourself. So as an advisor, this is one of the areas where you can give so much peace of mind to a client by making sure that the right people are authorized to make medical and financial decisions for your client if they lose capacity, because they could particularly come back and regain capacity and then have to live with the consequences of the decisions that were made. Another alternative is perhaps there are people who are trusted in a family or friendship group of a client who could make decisions for this client, but because they don't have the appropriate paperwork in place, everyone is tied up in red tape and bureaucracy, and decisions are delayed, and the right people can't actually take steps to make decisions simply because we didn't have the right paperwork. So for me, powers of attorney, and look, they're called all different things in different jurisdictions, so let's just stick with the generic phrase powers of attorney and guardianship, are one of the most vital pieces of an estate plan. But they're often overlooked by clients, particularly because they just focus on the will. So just to clarify, two key sort of events that you need to think about, and there'll be different names for the relevant documentation, but for the medical power of attorney decision making, that applies when a person loses capacity. And it is really important for family members to be authorised to be able to step in and make these decisions in a timely way and in an appropriate way for anyone who has lost capacity. We don't want a situation where people are just relying on it, defaulting to the next of kin, particularly if we've got a situation, a husband and wife will often say, my spouse will take care of it. What happens if they're in an accident together? Then who's authorised, especially if they've got young children? or the children won't all agree on the treatment. It's really important to just have the right paperwork in place. It eliminates any of this white noise and issues around who's authorised. The other side is the financial decisions. Now, for powers of attorney, for financial matters, you can actually choose when the financial power of attorney commences. So you can have it commencing when they lose capacity, or you can actually have it commencing immediately when a person signs the document. Now, people have different views around this. I personally have made my financial power of attorney commence immediately on signing it. And I've done this because of a few things. Firstly, if I am overseas, I want my family to be able to rely on that power of attorney to make any decisions that I might need them to do while I'm away. Alternatively, if something happens where I am slowly losing capacity, for instance, early onset dementia, and I have moments of lucidity and not, then I don't have to rely on my family being authorised by a doctor's report where they may be reluctant to say I've fully lost capacity, but then, for instance, the financial institution does not feel comfortable acting on my instructions and I'm stuck in no man's land. Having the power of attorney commence immediately just takes all of that white noise out of the equation. Alternatively, some clients are not comfortable with giving such extensive powers immediately, and they want it to start when they lose capacity. I think in that situation, it is really a matter of considering and talking the client through the scenario. I'm not advocating that you always have to have the financial power of attorney commenced immediately, but I would say that if you have concerns about somebody acting appropriately under a document while you are able and well and able to, take them to account, then perhaps you should be concerned about appointing them in a situation where you're at your most vulnerable. So the financial power of attorney, my point is, it is a really powerful document, can be really useful in a lot of situations. So I advocate to make sure for every client that they have not only a will but a power of attorney in place for medical and financial decisions. It just cuts out a heap of white noise and makes sure the right people are empowered to act promptly when they're needed. The other thing I want to labour is that not all assets are dealt with via the will. Have a think about this, or perhaps for your client. What is your biggest asset? Perhaps your super and life insurance? Not automatically covered by the will. For a lot of clients, particularly younger clients, most of their wealth comes if they've passed away because of the life insurance. Doesn't even get covered by the will. What about your family home? For a lot of people, all of their equity is tied up in their home. Covered by the will? Maybe. It depends. Sometimes it is. Sometimes it's not. Usually, if it's joint tenants, it won't be. Who knows? Does the client know? They probably don't even know the difference between joint tenants and tenants in common. I bet the real estate agent just filled that part of the form in for them. What about if you're in business? Is your business covered by your will? Yeah, no. Maybe, unless you own it personally. But trust or company, no. So let's go to super and life insurance. The starting point is it is not automatically covered by the will. Now, I'm not saying it's not covered by the will. I'm just saying it's not automatically covered by the will. So you have to turn your mind to where this wealth is going. And the only thing that will be binding on the super fund is a BDBN. The will cannot bind the super fund or gift the benefits of super or life insurance unless there is a BDBN to the legal personal representative, so aka the executor. If there is no BDBN, then the super benefits pass in accordance with the trustee's discretion. Now, the trustee may elect to pay the benefits into the estate to the legal personal representative, and in that case it will get distributed under the will. But the trustee may also elect to pay it straight to beneficiaries, and it will have nothing to do with the will. So if you want certainty, you need to have a BDBN, so binding death benefit nomination. BDBN, it's basically a will for super. So just recapping, when it comes to wealth in super, the starting point is that the trustee has discretion and they can pay it to the estate, which just basically means in accordance with the will or intestacy provisions, or to death benefit dependents directly, and in that case it will have nothing to do with the will. If you are not happy with trustee discretion, then you need to make a BDBN. So it's like a will for super, and it basically removes the trustee discretion and gives you certainty. And again, the BDBN can pay it to the estate or directly to the death benefit dependents. If you want your will to govern where super and life insurance and super goes, you need a BDBN, or you need to make sure that the right people are the trustees. So that brings me to my next question. Do you always need a BDPM? The answer, not always. It really comes down to balancing a whole range of factors, including whether you have a self-managed super fund or a retail fund, a blended family or not, and what's more important to you, flexibility or certainty. I mean, the super rules and the tax rules relating to where your super benefits go, I mean, it changes like every budget, right? This is a really evolving area. So where you don't need as much certainty, for a lot of clients, it makes sense to favour flexibility and for the family to get advice at the time after someone has died about where the benefits go. You know, we've got this $1.6 million pension cap, we've got the beneficiaries' circumstances, about whether they are at risk, whether they're under 25 and dependent or not. A whole range of factors that could depend on where the super should go. So I've got a little cheat sheet that I've put together here, and this is an example of the kinds of tools and cheat sheets that I have in my course, The Art of Estate Planning, to help narrow down when a BDBN will and won't be appropriate. So, for instance, if you've got a self-managed super fund, no risk of a family provision application, your executors are independent, then it may be that you don't need a BDBN, and it's better to have flexibility and leave it to the trustee's discretion. Alternatively, if there's a reversionary pension and a public offer fund, again, a BDBN may not be needed. In circumstances where you are establishing testamentary trust in the will, or you want to have several plans for contingencies in terms of the super goes to person A, but then if they don't survive, then to person B, then it could be really useful to have a BDBN to the legal personal representative to go to the. Contrast that if there are family provision application risks and they are not in New South Wales, it may be better to have the BDBN outside of the will. So there's all different factors that need to be considered for every client, and my main point here is that you cannot assume that the super will be governed by the will. Consideration needs to be given to where it should pass in different circumstances. So as an advisor, if you are looking at BDBNs for clients, and most of you will be, it's really important that you review and update your BDBNs regularly, or proactively take steps and decide that a BDBN is not appropriate. Consider what happens if there's a reversionary pension. Typically the BDBN will only apply after the reversionary pension, but it depends on the terms of the fund deed. Perhaps you need a BDBN that is silent if one spouse who is the recipient of the reversionary pension dies, and only applies after both pensioners have died. Be aware if your BDBNs are going to lapse after 3 years. This is pretty uncommon now, but there are still a lot of public offer funds that have the 3-year rule, so you need to make sure that they don't lapse and they stay valid. I also see, and I think advisors are usually pretty on top of this, but don't get caught out. Your nomination has to be valid to a valid death benefit dependent. So typically someone nominating their siblings, not going to be valid? What about changes in circumstances like divorce, relationship breakdown? And then aligning the BBBN strategy with the broader strategy in terms of looking at liquidity in the fund, pension caps, pensions, risks of challenge. So on its face, the BBBN's pretty simple form. A lot of funds will give you a template. There's actually a lot of strategy that needs to go behind to make sure that the strategy for passing the super and life insurance aligns with the will. Okay, let's talk about another aspect of people's wealth, their business structures. As we went over before, is it covered by the will? Yeah, nah. Like, assets in trusts and companies will not pass under a person's will. Instead, we have to transfer control of those vehicles. So the underlying assets on the balance sheet of the trust or the company can't keep it under the will. We have to hand over control. And if we're dealing with a trust, it turns on the terms of the trustee. You have to read the trust deed, okay, and look at who takes over control. In terms of companies, if the shares are held by an individual, then they can gift the shares under their will. But if they're owned in a trust, then it will have to pass under a trust plan. So the other thing to think about is all assets in a trust and company need the same succession plan. So if you have a trust that owns listed shares, a business and a residential property, and you've got 3 kids and you want each child to receive a different asset, like one child receives the shares, the other child receives the business, and the final child receives the property, you can't do it under the trust deed because all of those assets will remain in the trust and we have to hand over control. So, for example, here with our family trust, the assets that are in that trust will stay in that trust, and if our people who are the controllers die, so we've got up here they're the trustees, they're probably also the appointors, you have to nominate a successor to those roles so that the replacements jump in, and the successor can either be nominated usually in accordance with the will or by a separate deed. It depends on what the trust deed actually allows, or they might even default to someone like the executor. So you really need to find out what is the current plan in the trust deed, decide if that's appropriate, if you can rely on it, or if we need to change it. Generally, modern deeds will allow the legal personal representative, aka the executor, to take over, but you can't assume that. And then in terms of our trading company here, so this diagram represents, let's just jump back a moment, that the trading company is owned 100% by the family trust. To transfer the wealth in the trading company, we need to transfer control of the family trust. Whoever is the new controllers will take over the ultimate control of the wealth in the trading company. Contrast that with our corporate beneficiary over here. Because those shares are owned individually, then the benefit in those shares can be gifted under the will. But, you know, they're only going to have the right to benefit through distributions and dividends from the corporate beneficiary, and can't actually take ownership of the underlying assets. There's also issues here, depending on the company, whether you in fact need a power of attorney for the company as well, just to simplify things. So usually what would happen is the executors take over control. If we think about our corporate beneficiary, if they don't do a power of attorney, then the executors will take over control of their voting power as a shareholder. While the estate is being administered, the shareholders can pass a resolution to change the directors. So the company power of attorney is not critical, but there's more steps and delays to get the right directors appointed. If you want a really clean transition, and you know, particularly if we're talking about a trading company that has a lot of activities that need to happen all the time, a corporate power of attorney can be a really way to achieve a smooth transition of control. Contrast that if you've got a family trust with a corporate trustee, then the shares in that corporate trustee can be dealt with under the will, but be careful if you've got other control roles like the appointer, the principal, or the guardian, which would be governed by the trustee. So, excuse the jumping around. So in that case, we've actually need a two-pronged approach to make sure that control is passed appropriately. So my slides want to keep jumping to this slide. The trust deed is critical. You always have to read it and make sure you understand who the controllers are and what happens when they die. I was reading a client's trust deed recently, and it actually had one of their best friends in as the current appointer. The clients didn't even realise. And when I said, do you realise that your friend is in control of your trust and could actually remove you and take over the whole control? They had no idea. So make sure that you do read the trust deed, you understand who's in control now, and basically ask yourself these questions. Who's in control? What happens if they die? What happens if they're incapacitated? And just a little tip for young players, this incapacitated question comes up pretty frequently. If, of course, as relevant as a person dying. It's only been in the last couple of years that I think most trust deed providers are dealing with incapacity as much as death. So often, deed from the last 10, 15 years will say that if a person dies, their role passes to their executor, but they won't say what happens on incapacity. So it is important to have successors nominated on incapacity as well. Now, our last main asset that I want to cover off is the family home. Is it covered by the will? Sometimes. It depends. Really depends on, who's dying and how the property is held. So if it is held as joint tenants, then when one of the joint tenants dies, their will is totally irrelevant. The will only becomes relevant if both owners have died. Contrast that with tenants in common, then each owner can gift their share whoever they like. If the property is held by one person individually, then it should be gifted under their will, so the will applies in that case. We then have further complication. If they are using a testamentary trust in the will, we need to decide, do we want 100% or part of that property to go into a testamentary trust? Sometimes yes, sometimes no. So you might be aware that from capital gains tax, to get the principal place of residence CGT exemption, it's better for the property to be held 100% by an individual. But if that individual, the surviving spouse, is at high risk from bankruptcy or perhaps future relationship breakdowns, then you would want as much of that property to be held in a testamentary trust as possible. There are still ways to get the tax exemption if the property is held in a testamentary trust by relying on the ATO rulings and rights to occupy. That is a topic for a much longer video, but I just want to bring this to your attention. You need to turn your mind to it as an advisor. So the first thing, I think, when we're dealing with any kind of joint property, and that can be real property or even bank accounts, identify if it is joint tenants or tenants in common. Bank accounts will automatically be joint tenants. There was actually a decision coming out of the UK in the last few months which reiterated this principle and applies to Australia as well. So joint tenants and tenants in common, you guys probably do know this, but I just want to go over it to make sure everyone's on the same page. So joint tenants, it's basically survivor takes all. If one of our joint tenants dies, the other owner takes 100%. Doesn't matter what the first owner's will says. If they're trying to leave their property to the dog and cat's home, too bad. It will go to the surviving owner and they will take everything. So last man standing, basically, with joint tenants. And then when they die, it can go to the dog and cat's home under their will.
Contrast that with tenants in common. They each own their discrete share. It might be 50%, it might be, often it's like 99%, 1%. And in that case, if our wife dies and she wants to leave her 1% to the dog and cat's home in her will, she can. So both have advantages and disadvantages. So joint tenants is great if you've got a potential challenge and you're not in New South Wales. It goes straight to the survivor. You don't have to worry about probate for that property. You don't have to worry about it being in the challengeable pool. Alternatively, tenants in common, if we wanted our 99% interest to go into a testamentary trust because our surviving spouse was actually high risk at bankruptcy, then that's really helpful that it's tenants in common because we can divert it into the testamentary trust. Typically, unrelated parties will also own it as tenants in common. Most clients do not know the difference. If you ask them, you'll get a blank stare back or they'll just guess. And so it's really important to look at the title search. The rates notice won't tell you. So this is the first inquiry, joint tenants or tenants in common. The next thing you need to think about is if you're using a testamentary trust, so our trust triangle here is for a testamentary trust. Do we want our surviving spouse to have 100% of the family home and all the other wealth in the trust, favouring tax simplicity? Or do we want as much as possible of the home to go into the testamentary trust so that we have asset protection and then we're relying on a right to occupy and the tax office ruling to get the exemption on the final disposal of that property? So this is another thing to consider. Again, I've got a little cheat sheet here about where it should go and which structure is going to be appropriate. And again, this is one of the cheat sheets, a portion of a cheat sheet available in my course, The Art of Estate Planning, that I wanted to give you an example of, hopefully to just give you some really clear parameters around what's a sensible strategy. Obviously, you can't just rely on a cheat sheet and you need specific advice, but this is a little bit of some general rules. So that's enough of the technical stuff. I hope going through that today has really reinforced to you how much value you can add to a client's estate planning process by understanding these general principles and guiding them through their estate planning. Because a lot of clients will say, I've got a will in place. They won't even care if it's got a testamentary trust in it, and they'll think that they're done, and it may not achieve their objectives. So I feel that you are going to add so much value by understanding the wealth in their group, how that wealth is owned, and knowing some of these general principles so that you can guide the solicitors to make sure that they get a comprehensive estate plan. So I am so passionate that you should be taking advantage of estate planning in your business. To me, it just makes total sense in terms of building trust with your clients, creating peace of mind, and generating extra revenue from your existing client base. Estate planning is such a powerful conversation piece, right? Like the conversations that you have with clients about what their legacy should look like, what their goals are, what they want to provide for their family, who's in their family, getting to know everybody. Where else are you going to be able to have these conversations? Estate planning is just magic for building that trust, entrenching yourself as the trusted advisor, and having these conversations year on year as part of your annual review. Clients need peace of mind about this stuff. You know, less than 25% of people have a will, and I can tell you that even less than 25% of people have a comprehensive estate plan. So if you can help them get peace of mind by leveraging your existing relationship and project managing and facilitating this process, you are just adding so much value. And I know at the moment a lot of advisors are under pressure to substantiate your ongoing value proposition. To me, getting their estate planning sorted is such a powerful way of proving the value that you're adding by your ongoing relationship. And you know what?
sorts out some of the peace of mind for you as well, particularly if you're writing life insurance or reviewing the super, so that the money is going to the right people in the right structures. And lastly, there are tools out there that allow you to charge for your project and facilitation work. So if you could generate additional revenue from your existing clients, wouldn't you do it? So all of this, I just want to explain, has been the background to me creating the Art of Estate Planning course. So this is a 5-hour online program designed to teach you to use estate planning to, build that trust, get that peace of mind, and generate additional revenue from your existing clients. It is accredited for 5 CPD points, and it's basically a 5-module program delivered by me. So I've done my best to make it zesty and energetic and fresh and really practically focused, rather than a heap of boring, mundane, technical stuff, really focused on you as an advisor. What do you need to know from a practical conversation point of view to get estate planning up and running in your business, and to talk to your clients about estate planning and feel really confident doing it. So it covers off on everything that I think you need to know to get estate planning up and running. So some of the technical stuff, but then also some of the business focused stuff about how you actually do it. And as you've seen, it's full of really useful checklists and guides to make sure that you can systemize as much of it as possible. So it's only been live for a few, since August 2018, and already I'm getting some amazing feedback about what an invaluable tool it is for an advisor's business. So basically the outcomes that you'll achieve from the course, you will feel confident having sales conversations about estate planning, getting clients to overcome that inertia, and you can put your team through it as well so that they feel confident as well, so it's not just you. You'll be fully across testamentary trusts. You'll be able to get clients to overcome their inertia and choose the right legal provider to get your business up and running with estate planning. I also have some free toolkits for you. So I'm all about people just getting started and having a go at estate planning. There are some amazing untapped opportunities. Like, just think about how many of your clients right now do not have an up-to-date estate plan. So I've got some free downloadables for you to help you get going, start testing the waters, seeing what kind of untapped opportunities are out there for clients to start having estate planning conversations with them, and for you to start getting an estate planning offering up and running. So I hope I have done a good job at making you feel ready to unlock the power of estate planning to grow your business. Thank you so much for joining me. My contact details are on this slide. Head on over to my website, www.taraluke.com.au, and you'll see the Art of Estate Planning course up there. And get in touch if you've got any questions, because I really want to see you all start having estate planning conversations that work.